Welcome to Popcorn Planet. We are live, and I'm so happy to be back with Christopher Melcher, attorney at law. So good to see you, Chris. Thanks for coming back here.
Thanks, Andy. I'm glad to be breaking down this new appellate brief.
So we have been covering a lot of this, obviously. I'm trying to move on from this case, but obviously when Amber's appeal doc comes, it's something we got to respond to. We went through Johnny's. You gave a point system. I know we have you for about 30 minutes or so, so I want to make sure we use your time wisely here as we do sort of fast forward through this piece. It's about 68 pages, so it's long, but not, not the 80 and 90 we've seen in other things. But I want to go through this point. You've been able to skim through and sort of familiarize yourself with this. I guess before we even get to the statement of facts and everything, what are your broad sort of feelings? Does anything in here make you think, wow, she's got a good argument? Should Johnny be nervous?
Well, she makes a couple good points, and like any good lawyers will do. I don't think Johnny should be worried about this because most appeals are lost. The standard here to have a judgment or verdict reversed on appeal is almost impossible to meet. Amber has, her case, her kind of story to tell, and a jury could have believed that, but it didn't. And mostly this is based on facts and credibility. And so the Court of Appeal doesn't reassess the weight of the evidence, and it doesn't challenge a juror's assessment of credibility of a witness or party. So that's mostly what we're going to see her saying is, they should have believed me. Look at all my evidence. They shouldn't have believed Johnny. But that's not an appeal. That was the argument she made and lost in the trial court.
All right. So as we go through this, so she starts, obviously, there's table authority, statement of the case, assignment of error, and then statement of facts is sort of just the broad view of the things that she's reminding people of, correct? We need to go to the arguments. Can we just fast forward to her arguments? Is that the best place to start?
I think so.
Okay, so argument. So each of these numbers is her arguments, correct? And I can summarize here, and then I'll scroll down to those pages as Christopher sort of helps us sum it out. But do you want to go through A, B, C, D each, or are summarizing by one?
I think that's it. I think we a good appellate brief, and this is laid out well. We can really just go through this table of contents. I have gone through and read the whole detail of all this, but I think that table of contents is the roadmap for her arguments and kind of lays it out. And so the big point, this Roman numeral number 1, is saying this case should have never got to trial to begin with. So Amber tried to have it bounced out, dismissed before it even got to a jury. And one of the claims she makes in A is inconvenient forum, or in Latin, it's forum non conveniens. And she's basically saying, look, everybody was from California. And why was I, Amber, sued in Virginia? This is inconvenient. It should have been we should have done it in California. Now, she tried to have the case dismissed on that ground, and she lost. There was a legal basis for Johnny to sue in Virginia, which was that Washington Post, where she had her op-ed published, has its operations, or printing operations, I guess, in the state of Virginia. So this thing emanated from Virginia, and that's why he was able to sue there. Now, the real reason why he sued in Virginia is because they had laws that were much more liberal, I guess is one way of saying it, than California. In California, if he would have sued, he would have probably been tossed out and never got to trial, because in California we have a strong what's called anti-SLAPP law, which allows cases to be thrown out almost immediately if someone is sued for the exercise of First Amendment rights. And so here, Amber, if she would sued in California, would have filed that anti-SLAPP motion saying, look, I published an op-ed piece, an opinion editorial piece in the Washington Post. I'm being sued for it here in California by Johnny. That was the exercise of my First Amendment rights. And please throw this out immediately. And many of those are thrown out, and he would have to pay her attorney's fees. The reason why we have those strong laws in California is that a lot of people have been threatened and intimidated against speaking out against powerful, rich people or big companies, and with the threat of being sued. And that has what we call a chilling effect. So in California, we don't like that. So we have this really strong law. Virginia doesn't have, or at least when he sued, didn't have that law and allowed these to go to the jury. So that's the real reason. It was a brilliant legal maneuver by Johnny. And, hey, he had a legal right to sue. She's saying, no, he shouldn't have sued there. This has no chance of being successful on appeal because the trial judge in Virginia had what we call discretion to saying like, yeah, this is too inconvenient. It's too far from Amber's home to sue in Virginia, and could have thrown it out and made Johnny sue in California. But the judge heard all that evidence, exercised her discretion to saying no. And obviously Amber was able to mount a defense in Virginia. She had the resources. She had free lawyers paid by her insurance company to go represent her out there. So she was not in any way restricted from litigating in Virginia as if she would have been sued in California.
So yeah, this whole first portion is really a lot about the Virginia, which again is just frustrating because she's already made this argument and lost. Virginia's inconvenient, blah, 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 blah. Trial should have been dismissed, claims because the challenge statements are non-actionable expressions of opinion. So sort of along the same lines of why she says it should have been California. This is all trial should have been dismissed because the challenge statements are not reasonably capable of conveying a defamatory implication as a matter of law. Is that true?
Well, the thing is that this is the argument that she was making, what she's making there would have had legs had she not testified inconsistent with it. And I know we're bouncing around here a lot, but I think, okay, so 1B, so basically what she's saying here is like, I never mentioned Johnny's name in the op-ed piece, and that is true. If you read that op-ed piece, Johnny Depp's name not mentioned. So she's saying is that, hey, it's not about him, and no one could reasonably believe that I was talking about him. And so Johnny is suing under this concept of defamation by implication, meaning that a reasonable reader of that story with knowledge of, basic information would understand that they're talking about Johnny Depp, because she's saying, in 2018, 2 years ago, I became a public figure when I talked about X, Y, and Z. Well, that would have been 2016 when she was going through the divorce and she filed a restraining order. And so she was talking about Johnny. And now going into the trial, I was wondering how that would play out. Because again, they didn't mention the guy in the op-ed piece, but we all remember, those of us who watched the trial, Amber saying, yeah, I was talking about him. So it's like, okay, well, you've just admitted the fact now that you're claiming no reasonable person could infer. So this is a ridiculous argument.
So, right, if she had stuck her grounds in the, because even her own lawyer at one point admitted, of course it was about Johnny. Like there were numerous statements where it came very clear about the abuse of power of men like Johnny. Like she shoved her own foot in her mouth if she wanted to use this argument. So all this stuff that she claiming, trial court should dismiss Depp's claims because the doctrine of issue preclusion prevents relitigation of the UK's court ruling. Jesus. So because the UK court already ruled it, she's once again trying to say she shouldn't have even had a chance to fight it in the US?
Yeah, well, this is we have these concepts again, Latin, but res judicata or promissory, or estoppel, where we have concepts in the law that you can't relitigate an issue. So if we have the same parties, and that's a key, if we have the same parties involved in one case, on one issue, and a determination is made, they can't go to a different court and sue on the same issue and get an inconsistent result. So you get one shot at it. But for this to work, it has to be the same parties and the same issue having been litigated in the United Kingdom. But that's not what happened. In England, it was Johnny Depp who sued the Sun and I think the author of that story. Amber Heard was not a party to the UK action. So she fails on this argument because we weren't the same parties. So that's one problem. The court in Virginia looked at this very carefully in a long decision, said, even if I could get beyond the same party type of problem and overlook that fact, Johnny did not have a full opportunity to litigate in England, and that's also a requirement for this claim preclusion doctrine to work. And the reason why he didn't have a full opportunity is that he did not have the right to take what we call depositions of witnesses and find out all of their information and documents before trial. That is a difference in the UK system versus the US system. In the US system, I, as a lawyer, if I'm representing a party, can require people to come into my office or get on a video and answer questions under oath. We saw that with the doorman, and I can't believe I'm blanking on his name, but you know who I'm talking about, the doorman who at the Columbia building, who had to sit for a deposition in his car while he's vaping.
Our own Alejandro. Yep.
Alejandro. Sorry, Alejandro. That's an example of what we can do in the US is we just haul these people in and force them to answer our questions. In the UK, they don't do
unless
that.
You're Elon Musk.
Court permission. What's that?
Unless you're Elon Musk.
Yeah. Well, yeah. I mean, there's limits on hauling people in, but in the UK, you have to go to a judge. You have to get permission, which is unusual, I think, to be granted. And then the questioning is done in a courtroom, not in a lawyer's office. So Johnny didn't have the opportunity to question Amber like that. And he didn't have the opportunity to question the ACLU and Children's Hospital as to whether they got this money that Amber claimed or said under oath that she had given to them. And that was a significant fact in the English judgment. The English judge said, I really believe Amber because she gave the $7 million to charity. And had Johnny been able to get the information from those two entities, he would have been able to establish that that was a lie. She didn't give the $7 million. So in any event, that's why the Virginia courts before trial said, look, I'm not going to allow the UK judgment into evidence. It doesn't prove anything. And she's, resurrecting that claim. She will lose that claim. That's a dead bang loser on appeal.
Yeah, thank goodness, because that was insane. There were so many lies that got through on the that she got caught in that the UK ignored. All right, but so there already issue one, all turd burgers. Number two, trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. So Depp failed to prove by clear and convincing evidence that Heard was aware of and intended to communicate the alleged defamatory implications. Depp failed to prove it by clear and convincing evidence that Heard either knew the alleged implication that he had abused her was false or subjectively entertained serious doubts about its truth. What are your thoughts on part two?
Yeah, so 2A, is very similar to what we just talked about earlier. So in 2A, what she's saying is that that after they went through this trial and the jury rendered its verdict against her, that the court in Virginia should have thrown out that verdict because there was insufficient evidence to show that Amber was talking about Johnny in the op-ed piece. But as we've just mentioned, of course, she was talking about Johnny in the op-ed piece. She admitted that fact. And what she's trying to do in this argument is saying, forget what I said on the witness stand. Look only at the four corners of the op-ed piece, and no reasonable person would understand that I was talking about Johnny, if you just look at the four corners of the article, and therefore there's no proof. But again, that's not the way it works. The court and the jury can consider her admissions on the witness stand that she was actually talking about him. So that's a loser argument in 2A. In 2B, what she's going at is this actual malice thing. And again, actual malice is I wish they wouldn't use that term because it's very confusing. But in a defamation case, actual malice does not mean an evil state of mind. Actual malice means that Johnny had to prove that Amber either knew that her statements about Johnny were false, or that she acted with reckless disregard for the truth, meaning she didn't care whether it was true or false. She said it anyway. And what Amber's saying here is that after the verdict came out, finding that she had made these statements with actual malice, the judge should have thrown it out because there was insufficient evidence for the jury to make that conclusion. The problem here is that a jury had substantial evidence to make this determination. Here's why. If Amber would have just said, I felt abused in my relationship with Johnny Depp, you can't prove that that's true or false, because she is talking about a state of mind. It's subjective. She's saying, this is how I felt. And we all know, like, we can have a conversation with somebody or interaction with somebody and come away feeling one way that may not have been intended by the other side, but we have the right to feel how we feel. Yep. So if she had related, like, this is my state of mind, these are my feelings, this is how I perceived that relationship, there wouldn't be a case, because you can't get sued for that. But what she said was, I was a victim of, and I'm trying to clean up the language, but an attack. Mm-hmm. And an attack either happened or it didn't. That's objective. That's not a matter of perception. It's like, I don't feel like some people, like, you're attacking me. It's like, okay, I'm either somebody's laying hands on somebody or not. So she went there in the op-ed. And as a result, it's now a statement of, really fact or alleged fact. So what happened here is that the jury said, no, that did not happen. You were not attacked. And then when they get to the question of actual malice, well, how does Amber make a statement that the jury just found as false? You were not attacked. And then not find that it was done either intentionally, like you obviously lied, you knew that you lied because you weren't attacked, or you were acting so reckless about it that we're going to find you committed actual malice. So these things kind of go hand in hand. Because she stated something as a concrete fact that turned out to be false, the jury clearly had the ability then to conclude that she lied about it. She did that intentionally. She knew, she was conscious about it when she was lying about Johnny. And so that the jury had the right to make that conclusion. So I'm going to say, no way she's winning that on appeal.
So you're saying, had she said, in my opinion, my conspiracy theory, my whatever, before the op-ed piece, my feelings, it would have saved her, as Steph and I do on our shows. It really does make a difference to be like, speculating, I'm feeling here, that would have made all the difference.
It makes all the difference in the world, because anyone reading that op-ed piece then would understand this is her perception. And of course, Johnny would have a different perception. And I, as the reader of that, would say, okay, hey, I accept this is the way she feels. Doesn't necessarily mean that Johnny's a bad guy. Maybe I got to hear his side of the story to understand more about what's going on. I'm not going to walk away reading that op-ed piece thinking necessarily Johnny's a bad guy. I might feel sympathy for her because she had this relationship that she feels or perceives that she, all these negative things happened. And that's fine. That's her right to express that. But she didn't do that. So she didn't condition it. She didn't say, these are my, feelings or perceptions. She's saying, this happened to me.
And it feels like
when I spoke out about it, I was attacked further.
Yeah, sorry, but it just feels like she was like, because it's an op-ed, an opinion, editorial piece, she's sort of using that as, well, that's what I meant. But an op-ed almost is just more to protect the publisher, right? Of, this isn't news, this is her feelings on things, and she's still got to do a clearer job in saying it in her opinion piece that this is feelings, this isn't factual.
That's right. I mean, for in a traditional, like when we go back to when we used to have newspapers, but there was a news section which were, hard facts, hopefully, like
not anymore, but
war in Ukraine. This is what's happening on the ground in war in Ukraine. And then they would have an op-ed piece that would maybe say like, hey, should we be taking this position politically or economically or not, or whatever? And those are clearly opinions. There's not facts on the ground. So that's where that distinction comes from in the newsroom. But, here again, it's like, yes, she was writing an opinion piece, but she was stating things as fact to support her opinions. And that's where she got into trouble.
All right, I want to get, because I know we have a limited time with you, but the trial court erred in failing to grant a new trial for multiple reasons. So a lot of reasons she puts in here, but made numerous evidently errors that severely prejudiced Heard at trial. Trial court erred by excluding evidence of Depp's abuse and Heard's state of mind. Heard's reports of to medical providers, which was the therapist, which again, we understood why. Trial court wrongly excluded corroborating testimony of Heard's allegations. I don't even know which one that is, but we'll go through.
Yeah.
Trial court improperly excluded the UK judgment. Again, all stuff we've heard before. Trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements. Trial court erroneously admitted irrelevant and prejudicial evidence. Trial court, I mean, there's a lot here.
Yeah, we can break these down pretty quick. If we go back to 1A, okay? So what she's saying here is like, look, there were evidence that she wanted the jury to hear, information that she wanted the jury to hear, that this judge said, no, I'm not allowing the jury to hear that. Now,
that went both ways, mind you, too. Let's not forget, because Depp didn't get to put some things in as well, correct?
This happens in every trial, and that's the role of the judge, is really like a referee in a sports game, is to call the balls and strikes and determine, like flow of the game. Like we have to, everyone wants to be heard. There's a lot of information that they want to present, and the judge has to say, hey, this is important enough for the jury to hear, or this is really not relevant, or it's really a bunch of nonsense what you're saying, it's not supported, there's other policy reasons why we're not going to allow it in, and the judge gets to make that decision. And so both sides in every case like this had information that they wanted the jury to hear. Now in this little A here, Heard reports of abuse to medical providers were admissible. What she's saying here is that and legally, if we got lawyers listening to this, is a prior consistent statement. So what she's saying here is that she had told a therapist or a doctor, or several of them, she says, there's some bullet points where she goes through
several medical
here,
professionals as a result. Yep.
That, prior to the breakup in 2016, for several years, she had made some reports about Johnny of abusive conduct. And she wanted to introduce that into evidence. Now, normally, if you're not a lawyer, you would think like, wow, that's pretty good to go. I mean, but in the law, we generally do not allow what we call prior consistent statements. And the reason is that logically speaking, if somebody's going to lie, well, they always going to lie about this thing, and repeating a lie doesn't make it true. So it doesn't make it true that Johnny Depp is an abusive person if you tell it to a whole bunch of people, right? So she can go on the witness stand and saying, this is what happened to me. The judge can look, the jurors can look her in the eye and determine whether she, is telling the truth or not, without having to saying like, oh, and I've said the same story 2 or 3 times over again. There is an exception where prior consistent statements are allowed when there's an allegation made that somebody has recently made up a story and, kind of recently concocted it. Well, then you can go back in time and saying like, hey, I didn't just make this up. I said this 5 or 10 years ago. Okay, so we've seen that in the Danny Masterson case where that was allowed. So that's where she's trying to come into and saying like, hey, I didn't just make this up. I've been saying it earlier. The problem is that some of the statements were not necessarily on point to what her said in her op-ed. So there's a reason some of these statements were not, it's just like, it's not clear enough that she was saying back then the same thing she said in the op-ed. The other thing is that there was also a joint therapist, and to get joint therapy stuff in, generally Johnny would have to waive the privilege. Another thing is that, what exactly did she say, and how well documented is that in these therapy or medical notes? Because they're not taking a verbatim thing. They're kind of taking information and quickly just jotting it down. So we have issues of what really was said. And so the problem that the court faces is like, okay, look, Amber, if I allow this in that you want, I also then have to then bring in that therapist, bring in the doctor, cross-examine what exactly was said, and it becomes this big production here and takes up a lot of trial time based on very minimal weight to that evidence because, Amber, you can just go and tell the jury like everything that happened to you. You're going to be on the stand for 3 or 4 days, and the jury can see whether you're telling the truth or not. Bringing in some scribbled note from 10 years ago
Right.
and trying to
Where
determine what
told
you actually
somebody
said
something,
isn't
yeah.
that great.
Because I know you're on a clock here.
Yeah.
I will go through these with you guys as Christopher leaves, because there's a lot of evidence that's actually talked about, and this portion of it's probably worth going through. But
Yep.
again, more excluding testimony. It's all stuff that the judge deemed not there, and in your purview, there's nothing was wrongfully excluded. You think everything was?
I mean, the little B thing is Deuters on some plane told Johnny something about being, like you kicked her or something in the back or hit her, and Johnny had some kind of reaction to it, and that was excluded. There was one of the other things that might be on that next page there. Yeah, that
because again, UK trial court erred when precluded Depp from answering a question about the truth of one of the statements. Trial court admitted irrelevant prejudicial evidence, which we'll go through these guys, but nothing in here was surprising or was worried.
No, I mean, the question
Johnny's
on Johnny was, they asked him, like, did you commit abuse? And the judge said, well, that's a legal conclusion. You got to ask him the facts. Like, did you hit her? Did you punch her? Did you, do whatever? Get me the facts. Don't ask him a conclusion. So that's 3. 4 just deals with, I mean, it's ridiculous. They're saying they should not have allowed evidence about this pledge versus donate thing. That was highly relevant. And of course, that should have gotten into evidence. These are her own words, by the way, not somebody else's words. So, and then the record of what did she actually, give in cash to these charities? That was highly relevant to her credibility. So that was not erroneous to allow that in. So basically, all of that stuff, I really don't see that going anywhere. There was also some stuff here about the instructions in C to the jury. Now, those are usually the best arguments because it's the judge's obligation to correctly instruct the jury on what the law is, because the jury doesn't know what the law is. So they got to be told, like, here are the elements or definition of actual malice. And if the judge screws that up, well, of course, the verdict's going to be messed up and has to be tossed. But they got that right. I think that the definition is not that complicated. They had input on what that definition should be. So I think the jury was properly instructed on there. So I'm not really seeing that this is a problem here. The inconsistency, she's going in and saying, like, well, how could Adam Waldman's statements about Amber be, defamatory, but then her statements about Johnny also be defamatory? Well, yeah, there's clearly, it can be consistent. Those two things can exist. They're
That's
not.
D. And then, this idea that the claim based on the headline for the web version of the op-ed, because that I've established that Heard did not publish it. Again, they fought that so hard in the trial. And again, it didn't matter. All this stuff is not stuff we haven't heard before. So it's all just a bunch of rehash. And it does really feel like more of a PR statement in a way of, here are the bullet points to prove why Amber was mistreated by the jurors and the jury. Do you get that vibe?
I don't. Where I get it is, it's like, hey, you never know. And I've lost appeals that I thought were dead bang winners, and vice versa. So, there is a degree of unpredictability in all of this, and we just don't know. There could be a justice on the Court of Appeal that loves Amber Heard and thinks that she got a raw deal and maybe doesn't care about any of this stuff and wants to change things. We don't know. And so that's what they're doing. They're throwing it against the wall, hoping something sticks and get it unwound. And that's her right to do.
Do you think they threw enough at the wall here as we wrap up your conclusion, your thoughts? What final thoughts on this?
Well, I mean, it's a legitimate legal brief. I think to me,
she did the work.
What?
Like you give her credit because she did the work finally.
Well, I mean, it's like, look, I mean, it's a well-constructed brief. I think where it fails, what I would have done is, you got to put your best arguments forward and not have these distracting, really weak arguments. So to me, I would have been more worried about it had she not put so much junk in there, because then the focus, because you when we're going to court, in Court of Appeal, it's like they have limited time. So it's like, give me what you got quick.
Yep.
And it's like, you got to hit it. And it's like, oh yeah, I see that. I'm on board with you. And if it's like, give me what you got. Oh, I should have been sued in California, not Virginia. It's like, no. Okay. So and then you get fatigued as the reader or as the justice. And it's like, okay, yeah, now I'm getting now here down. That maybe the good arguments are actually towards the end of this brief. You want to put the good arguments in the beginning and get rid of the crap. So I think my criticism of her is that, or her attorneys, is that they said, let me just make every argument that I conceive of. And that's not good advocacy. So I think that's going to weaken maybe the one or two decent points that she's making.
What's the most important point you see? Which, when you say there is a decent point, which one is the most nerve-wracking, should be for Johnny's team?
I think the ones that concern me are about the evidence of, what she told therapists or doctors. I think the judge had a good basis to exclude that. But, hey, I mean, who's to say, like, if the jury would have heard maybe a little bit more evidence, might have said, oh my God, now I believe everything that Amber had to say. I think that's what Johnny's going to come back on and saying is like, look, even if that evidence had been admitted, there were not a thousand, but there were lots of reasons why the jury would still not believe her. And that we have to also keep that in mind in context, is that, again, as me as the viewer of every moment of that trial, I found her not to be credible based on her own testimony. It wasn't what Johnny or his witnesses said or what his lawyers did. It was Amber's own testimony under questioning by her own lawyer, not under cross by Camille, by her own lawyer. Softball questions. She was plainly lying in my view. So had I heard evidence that she told some other doctor 10 years ago or therapist something, it would not have swayed me. So I think that's where Johnny's going to come back and saying look, this lady lied on the stand and the jury had good reason to find her not credible. And the introduction of some note that was scribbled by a therapist 10 years ago wasn't going to change what they saw on the stand.
Interesting. Well, I appreciate Christopher. I know he's got to go. Thanks for staying here as long as you did. Go follow Christopher Melcher over on Twitter. We will keep you posted. If more things come out, we will break them down for you. Always a pleasure, sir. Thank you for being here.
Thank you.
Enjoy your day. All right, we're not done, though. I'm going to read and take care, Christopher. Thank you so much. I'm going to trim this portion of the show. If you want to watch the full show, I'm going to go through some more of that evidence in this appeal right now with you guys live. But if you missed it, hit that join. Oh, it's not showing up. Why is that button? It's not. Hit the join. It's right next to subscribe there. Pick a tier, and you'll be able to watch the full shows on replays as a member of Popcorn Planet. Love my Planeteers. Throw some planets in the chat right now if you're there. And thank you guys for supporting the channel.